Welcome back to Sunrise Daily. We'll continue our focus on the constitutional amendment. Well, the House of Reps are taking their own version of that. Well, we're going back to Abuja Studios, where Honorable Femi Gbajabiamila joins us. Is the minority leader of the House of Representatives. More than I thank you for joining us today. Well, let's start off with the immunity clause. Could you tell us, what is the rationale behind the House of Reps' vote to remove it?
Well, thank you. First of all, the removal of the immunity clause is the decision of the House, and we abide by it. Does not necessarily mean that we were all in agreement on that, on the removal of that clause. Personally, I felt that clause should have remained in the Constitution. The working and the thinking of the members of the Assembly was simply because, again, a lot of governors had abused that clause and used it as a shield to perpetuate a lot of criminality. But unfortunately, there's a reason for the immunity clause in the first place. It's something you find in most advanced democracies. The immunity clause, as it was then, was not an absolute clause. It was not absolute immunity. Again, you could be investigated as a governor, you could be investigated as a president, and the statute of limitations is told until you leave office. That's when it begins to tick. In any case, there's no statute of limitations when it comes to criminal cases anyway. So I felt, and some of us felt, a lot of us felt that that clause should have remained, because when you balance the equities, the merits of removing it, or rather the demerits of removing it far outweigh the merits of leaving it in place. Today, we all know what is going on in Nigeria. We know what our climate is. If that clause stays, if it passes and is part of the Constitution, governance is going to come to a standstill. We can see what's happening in Rivers State, for example. Now, if there was no immunity clause in Rivers State, the governor of Rivers State today will be in court. If for nothing else, framed up charges, possibly conspiracy to inflict bodily harm on a member of the legislative arm of government, which is what has been the story that has been bandied around the whole place now. So, again, the rationale for the removal is pretty obvious. People want to hold government, governors and presidents to account. But in doing that, I don't think that was the way to go. I think the immunity clause, again, not being absolute, should have remained, and accountability will then start after your term of office.
Can the House of Reps reverse itself procedurally or otherwise?
Yes, even I was talking to some people regarding the 29(4)(b) clause that has generated so much controversy. Both the House and the Senate can revert themselves, or rescind is the word we use. You can rescind your decision through a motion of rescission. We have that in our rules. They have that in their rules. And that's really in the face of a more compelling argument or evidence that was not available to you at the time. Even courts rescind themselves sometimes. So yes, it's not an absolute thing. Yes, you can rescind yourself. Yes.
Okay. Well, what do you make of the arguments for those who say, and again, with due respect to the House, that they missed the point on this one because they think that removing that clause perhaps doesn't really matter. What they should have focused on is the criminal justice system in the country. Because they talk about several cases at the time where Malam Nuhu Ibadu was EFCC chairman. Till date, no one of them had been prosecuted. And so they should have focused on enhancing the criminal justice system in the country.
Well, I mean, it's easy to sit back and criticize. What you have to look at is not what you have to look at was what motivated the removal of the clause. It was done in good faith. The motivation, for me, the motivation was good. But the question is, was that the answer to the problem? I don't think that was the answer to the problem. So I wouldn't go ahead and criticize. It's a House decision, and I stand by it. But I have my own personal opinion that maybe we shouldn't have gone that route. I didn't vote for it. A lot of our members did not vote for it. But then to then sit back and criticize and begin to play Monday morning quarterback is not, I don't think is the way to go. We have public hearings. Those who criticize and say that's not the way to go should have come forward during the public hearing, which was conducted in practically every local government of the Federation. So you cannot, if you don't participate in the process of amendment, I really think you cannot be heard to complain later. You get exactly what is given to you. But most importantly, it was not an ill-motivated amendment. The House did what it thought it was in the best interest of the country. We all know what people say about governors. We all know what people say about the president. We all know what people say about the executive, whether rightly or wrongly. And the House wanted to do the bidding of the people. That's another thing you have to take into consideration. The constituents actually voted for the removal of the immunity clause, and for as long as we're representatives, we need to move as close, not necessarily 100%, and that's my own opinion, but as close as to the wishes of the people as we can. So so we must all take responsibility, both the constituents and the National Assembly, for the removal of the immunity clause.
All right, be that as it may, but you have some lawyers who say they came up with some recommendation, but their voices were drowned out by what they refer to as majority in a democracy such as ours. They cited Section 40 of the EFCC Act, and it says, quote, subject to the provision of the Constitution of the Federal Republic of Nigeria, 1999, an application for stay of proceedings in respect of any criminal matter brought by the Commission before the High Court shall not be entertained until judgment is delivered by the High Court. End of quote. Now, Festus Keyamo suggested that this Section 40 be amended and put in the Constitution to enhance that process. And he says memoranda was submitted to the House, but I guess maybe slipped or wasn't seen by the House.
Well, I mean, I guess the House was not persuaded by his argument. You must also understand something, that it's not everything that really should go into a constitution. If you look world over, constitutions are probably the thinnest documents you can see that are supposed to guide the workings of government. And some countries even have, like Great Britain, even have unwritten constitutions, and their constitutions are based on court decisions and customs over the years. So by the time you begin to put all these things in the constitution, where do you stop? Where do you draw the line? What the constitution has done is to give a broad guideline upon which you can now, pass other laws, either the National Assembly or if it's in the residual list by the states. I'm not saying Keyamo was wrong, but unfortunately, his is just one voice, and I guess 460 members of the National Assembly thought otherwise.
Mr. Gbajabiamila, the question that many people out there ask is the House of Representatives bothered about the implementation of the Constitution, or the implementation of the Constitution as against just amending?
The implementation is against amended. Well, if the Constitution is not implemented, then the House has itself to blame for that. It is the responsibility of the House or the National Assembly to make sure the provisions of the Constitution, or any law for that matter, is implemented. That's probably one of the most critical functions of the legislative arm of government, and it's called checks and balances and oversighting. We cannot complain or be concerned about implementation. Yes, implementation is a problem, and I quite agree with that. It's not really so much amendment. If our Constitution was operated and implemented to the letter, as it was even before this amendment, I think we would have gone a little bit further as a nation. United States of America from birth has only had about mid-20s, about 25, 26 amendments thereabouts. So it's about the operation of the Constitution. I agree. But no constitution, no document is perfect. And if you find areas where you need to tweak and tighten, loose ends, yes, we'll do that. But no matter how much you amend the Constitution, No matter how far you amend or how often you amend the Constitution, if it's not implemented, if it's not operated the way it's meant to be, then you're back to square one. So I agree with that. I agree with that. But that does not mean you shouldn't amend it where you find lacunas.
But in this case, the immunity clause and the local government autonomy appear to be the most pressing issues that the House decided to focus on. Why did you choose this?
It wasn't the choice of the House. It was what was on the front burner for Nigeria and for Nigerians. There are a lot of other issues, of course. And again, constitutional amendment, as Nigeria knows it, is an ongoing process. There are other issues that we would look into when we come back in September. It's not amendment has not been foreclosed. But the main amendments as we have it today is what we have passed. So for me, it's an ongoing process, and we'll continue to look into areas where the Constitution needs to be amended.
Well, let me take you to a democracy that you're quite familiar with now, to the United States. And if you look at what we've been talking about, we'll still come to the local government issue. But this has to do with President Clinton, President Nixon, and as a whole lot of other people who were actually tried or investigated while they were in office. So if you bring that to this immunity argument in Nigeria, how can we replicate such to the extent that even though, well, there's no immunity for you, we can have a decent trial or investigation of officers and public officers while in office?
Well, that's I think that's even really nothing for the Constitution. That's a law that needs to be made. If we need to, if we find that you see, the EFCC, for instance, could have done this, and the EFCC is supposed to be independent. But for a lot of people, for all intents and purposes, it's not. It's still beholden to the powers that be or whoever appoints the EFCC chairman. And these are areas that we may need to look at in terms of appointment. But in the United States that you refer to, you have what you call the special prosecutor, who is independent, who is not, I believe, not appointed by the president. It was a special prosecutor that investigated Bill Clinton during the Monica Lewinsky scandal. We don't have any such thing here. Perhaps that's what we need to start looking at. To look at a body that is independent, appointed, without the input of the president, to look at various allegations against people who are in positions of authority, so that we can have an unbiased investigation. And then, like I said, the Supreme Court has ruled on this anyway. You can investigate a governor or a president. You cannot prosecute while they're in office, but you can investigate. We haven't had any such thing happen so far, and we need to start working on how to ensure that can be done.